We are going to discuss 43rd lesson, Judicial Control over Administration, in the syllabus of the Indian administration. The main objectives of this study: the importance of the judicial control over administration, understanding the judicial activism in India. Introduction. Judicial control over administration means the powers of the courts to examine the legality of the officials' acts and thereby to safeguard the rights of the citizens. It also implies the right of an aggrieved citizen to bring a civil or criminal suit in a court of law against a public servant for wrong done to him in the course of discharge of his public duty. The exercise of official authority may on occasion encroach upon the constitutional or statutory rights of the individuals, whether by reason of error, misunderstanding, or excessive zeal. Increased administrative powers have necessitated increased safeguards against their abuses. Judicial control, what is it? Judicial control over administration means the powers of the courts to examine the legality of the official acts and thereby to safeguard the rights of the citizens. It also implies the right of an aggrieved citizen to bring a civil or a criminal suit in a court of law against a public servant for the wrong done to him in the course of discharge of this public duty. The end sought by judicial control of administrative acts to ensure their legality and thus protect the citizen against unlawful trespass on their constitutional or other rights. The judiciary intervenes into administrative cases on the following grounds. 1. Lack of jurisdiction. It means every officer has to act within the limits of the authority given to him and also within a specified geographical area. If he acts beyond his authority or outside the geographical limits of his powers, his acts will be declared by the courts as ultra vires and hence interactive. As for example, in India, it is expressly laid down in the Constitution that no government employee shall be dismissed by an authority below rank to the authority which appointed him. Otherwise, the action of the dismissal shall be declared ultra vires due to lack of jurisdiction. Error of law. A public servant may misinterpret the law and may impose upon the citizen duties and obligations which are not required by law. A citizen who has suffered on account of this has a right to approach the court for damages. Error of fact finding. Thirdly, there may be cases in which the official has erred in his discovering the facts. He may wrongly interpret facts or ignore them and thus may act on wrong presumptions. This may affect a citizen adversely, and so there may be ground for bringing a case in a court of law. Abuse of authority. If a public official uses his authority vindictively to harm some person, the courts can intervene and punish him if he is found guilty of using the authority to take a personal revenge. Error of authority. Above all, public officials have to act according to a certain procedure as laid down by laws, and if they do not follow the prescribed procedure, the courts have a right to question the legality of their action and appeal from the party affected. Methods of judicial control. Control of administration by the courts may take one of the following forms. 1. Judicial review. 2. Statutory appeals. 3. Suits against government officials. 4. Extraordinary remedies in the form of writs. By judicial review, we mean the power of the courts to review the administrative acts and decisions for their validity. On examination, and acts are found to be ultra vires. We have used this word previously also. The meaning of the ultra vires means Latin meaning beyond the powers, describes actions taken by government bodies or corporations that exceed the scope of power given to them by laws or corporate charters. Statutory appeals. Statutory appeal occurs where certain provisions of the statute themselves provide for appeal against administrative decisions and actions. By virtue of such provisions of the statutes, the adversely affected or aggrieved citizens will have the right to appeal to a court or a higher administrative tribunal. Suits against the government. Judicial intervention can be in the form of suing the government itself or the public official concerned against whom any citizens may want to be redressed of his grievance. Extraordinary judicial remedies. The extraordinary judicial remedies consist of 1. Habeas corpus, 2. Mandamus, 3. Certiorari, 4. Prohibition, 5. Quo warranto. In England, these are known as a prerogative orders or common law remedies. To these may be added to a sixth one called as injunction. Number 1. Habeas corpus. Habeas corpus literally means you may have the body. It is a court order issued to a public official who has another person in custody. The writ requires the detainer to show the court that the detention is proper. Mandamus. Mandamus literally means we command. By issuing this writ, the court can compel any public officer to perform a duty which results from his official position. Thus, this writ is useful to enforce a public duty which an officer falls to perform. Certiorari. It means to be certified. This writ is issued by a superior court to an inferior court for removing the records of some proceedings from the inferior court to the superior one for the purpose of determining the legality of the proceedings. Prohibition. This writ is used to bring the decision of an inferior court from up for review and to quash the decision in if necessary. The basic defect of this writ, like certiorari, is that it will be lie in respect of only judicial acts. Both certiorari and prohibition do not lie in those cases where the public authority is acting in a purely administrative or ministerial capacity. Quo warranto. Quo warranto means by what authority? It is a writ issued by the courts to inquire into the right of an occupant of a public office to hold the office. The action will normally be brought by a person who claims the office judgment. Injunction is one of the most important methods of judicial control over administrative officers. It is a writ that is preventive in nature. Normally, an injunction requires the person to whom it is issued to refrain from doing a particular thing or a specified activity. Certain exceptions to the rule of law, particularly USA, UK and India. It may be mentioned here that even in countries following the rule of law system, there are certain people like the head of the state who enjoy legal immunity and are not amenable to the ordinary courts of the land. For example, the British monarch is completely immune from legal liability in respect of any of his or her acts done in public or private capacity. That is, they call the king can do no wrong is a legally accepted phrase in England. The American president is also immune from any legal proceedings during the term of his office. In India, personal immunity from legal liability is granted to the President of the Union and the governors of the states for any act done in exercise of their powers and duties as laid down in the Constitution. The ministers have, however, no such immunity and they are therefore liable for crimes and torts and amenable to the ordinary courts. Limitations of judicial control. The judicial remedies mentioned above provide an effective control against official excesses of abuse of power and in protecting the liberties and rights of the citizens. However, judicial controls are also subject to certain limitations. They are exclusion of some acts. All administrative actions are not subject to judicial control. there are many kinds of administrative actions which according to constitution cannot reviewed by the law of courts. Then there is a tendency on the part of the legislature also to exclude by law certain administrative acts from the jurisdiction of the judiciary. Lack of suo motu powers. It can intervene only on the request of the somebody who has been affected or is likely to be affected by an official action. This imposes a serious limitation on the extent of judicial control, as most of the injustices suffered by administrative excessives are not reported. Dilatory procedure. The judicial process is very slow and cumbersome. The courts follow certain set technical pattern of a procedure beyond the comprehension of a layman. The procedure is so lengthy that it cannot be known as to when the final judgment shall be given. Inadequate and ineffective remedies. Sometimes the remedies offered by the law courts are inadequate and ineffective. In many cases, especially relating in business activities, mere announcement of an administrative action or even a reminder concerning a proposed action may cause an injury to the individual against whom not even a suit can be filed in the law court. Expensive procedures. Judicial action is prohibitively expensive. Hence, a common man cannot take advantage of judicial interventions. Moreover, the procedure causes a great deal of inconvenience to the litigant, and hence it is a general feeling that it is better to keep away from litigations. Lack of expertise. The highly technical nature of most of the administrative actions saps the force of judicial review. The judges are only legal experts and they may have little knowledge of the technicalities and complexities of administrative problems. Their legal bent of mind may hinder them in arriving at a right decision. They have to follow the prescribed procedures and observe some formalities. Overcoming the limitations of judicial review. The government has taken a few steps to offset the above mentioned lacunae in the process of judicial intervention into administrative action. The most important among them is PIL, Public Interest Litigation, a useful judicial innovation in India which has developed in recent times is the public interest litigation. This has been a progressive trend in judicial remedies against citizens complied not only in our country but also in various other countries like USA, UK. The Supreme Court in 1978 has propounded a liberal view of standing so as to provide judicial redress for public injury arising out of any breach of public duty on from violation of the Constitution. Complaints involving maladministration like patients not getting a proper medicine in government hospitals, inefficient administration of prisons, failure of administration and checking environmental pollution, irregularities in the administration of educational institutions, etc. are being challenged under the category of public interest. The rules of Supreme Court, which were revised to bring in this provision, facilitate any citizen or group of citizens to appeal to the court on behalf of any group of people affected by any act of government. So, even if the citizen himself has no personal complaint against the administration, he can still lodge a complaint against the administrative injustice which according to him is being done. The public interest litigation has acts as a catalyst in providing additional protection and securing social justice to citizens in India, especially to the poor and illiterate. Judicial activism. Judicial activism is a concept that originated in America in 1947. It has been seen in India since the emergency days. Judiciary and judicial activism are important topics to the students of Indian administration and polity. The judiciary plays an important role in upholding and promoting the rights of citizens in a country. The active role of the judiciary in upholding the rights of citizens and preserving the constitutional and legal system of the country is known as judicial activism. This entails sometimes overstepping into the territories of the executive. Judicial activism is the exercise of the power of judicial review to set aside government acts. Generally, the phrase is used to identify undesirable exercises of that power, but there is a little agreement on which instances are undesirable. Judicial activism is not an easy concept to define. It means different things to different persons. Critics denounce judicial decisions as activist when they do not agree with them. Activism, like beauty, is often in the eye of the beholder. In India, the opening up of access to courts to the poor, indigent and disadvantaged sections of the nation through public interest litigation, popularly known by its acronym PIL, is unexceptionable judicial activism. From 1979, the judiciary led by the Supreme Court of India became relevant to the nation in a manner not contemplated by the makers of the Constitution and became an active participant in the dispenser of social justice. Judicial activism is seen as a success in liberalizing access to justice and giving relief to disadvantaged groups because of the efforts of Justice V.R. Krishna Iyer and P.N. Bhagavati. Public interest litigation is a good thing when it is used to enforce the rights of the disadvantaged. This is a type of judicial activism unparalleled in any other judiciary. Under the Article 32 of the Constitution, the PILs are heard by the Supreme Court and High Courts by an individual or a group of people if one or more of their fundamental rights are violated. PIL jurisdiction began haltingly with the little idea of its potential when the Supreme Court in 1979 entertained complaints by social activists drawing the attention of the court to the conditions of certain sections of society or institutions which were deprived of their basic rights. However, over the years, the social action dimension of a PIL has been diluted and eclipsed by another type of public cause litigation in courts. In this type of a litigation, the court's intervention is not sought for enforcing the rights of the disadvantaged or poor sections of the society, but simply for correcting the actions or omissions of the executive or public officials or departments of government or public bodies. Examples of this type of intervention by the court are innumerable. In the interest of preventing pollution, the Supreme Court ordered control over automobile emissions, air and noise and traffic pollution, gave orders for parking changes, wearing of helmets in cities, cleanliness in housing colonies, disposal of garbage, control of traffic in New Delhi, made compulsory the wearing of seat belts, ordered action plans to control and prevent the monkey menace in cities and towns, ordered measures to prevent accidents at unmanned railway level crossings, prevent ragging of college freshmen, for collection and storage in blood banks, and for control of loudspeakers and banning of firecrackers. Judicial activism in India implies the authority of the Supreme Court and the High Courts, but not the subordinate courts, to declare the regulations unconstitutional and void if they breach or if the legislation is incompatible with one or more of the constitutional clauses. The role of judicial activism cannot be negated or overlooked, as it played a significant role in providing justice to the underprivileged sections of the society, indigent individuals, socially and educationally backward classes, victims of trafficking and under trial prisoners. Proper implementation of fundamental rights could only become possible due to the advancement of judicial activism. There is a narrow demarcation between activism and overreach. Sometimes, in the process of judicial activism, the judiciary intervenes too much and reflects its personal beliefs in the course of providing justice. The interpretation of law, which is the primarily function of judiciary, but the courts, rather than interpreting the law, start making the law, issue guidelines and directions, which is to be done by the legislature.